involvement of students. What is moot court? You all of know that it is a mock trial. One fictitious problem is given to you, or any real problem is also there, because considering that development in the technology, so many problems all are facing. This technology is much easy to live in the world, but it is very hard to prove the legal problems, solve the legal problems. Therefore, to have a better idea of the problems in the life, because the problems in the life automatically come into the court, because there is no solution everywhere in the society, and therefore court is there to solve these problems. And how to tackle with the situation, that is the problem given to you. In this moot court competition also one problem is given for the students, and their preparation will be now assessed by the panel members. Two panel members are already here, and they will assess your argumentative capacity, your presentation. It is heard that there are 10 teams are going to be participated in this moot court problem, and already the subject is circulated all of you, and you must have come with the preparation. So the basic idea of moot court is to simulated court competition where students or participants, typically law students, argue fictional or legal cases in a mock setting. But what benefits you students are going to get out of participating this moot court competition is, it develops your advocacy. What is the advocacy? You people may not know at this stage, because you are not full-fledged lawyers. And when you first step into the court hall before a judge and before the court clerks even, your legs get shivering, and what to argue before the court, what to make submissions before the court. In a first day, I remember my first case, I forgot each and everything what I had prepared. But this moot court competition gives you that idea, because you are facing one mock trial here, and that advocacy. And in advocacy, not only the presentation is included, but how you present, what you present, whether there are any legal contents in your submission, because submission in the court is not a mere talking with the court, not mere talking with the judge, but it's a submission. It is supported by the legal provisions, facts of the case, and the first and foremost concept here is that you should be well versed with the facts of the case.
No such moot courts. So immediately I grasped the lecture of Honorable Chief Guest that why moot court competitions are essential. In our golden times, around our 1969-70, no one was a guide for us how to prepare the case. First of all, we were not knowing about the case itself, the facts, its law, how all these things should be gathered together. And I will tell you my own experience, that it was a sad experience, that in 1974-73 my father expired, and in 1974 immediately within 6 months I was required to continue the profession of my father. Just I was past LLB, 3rd year, and I was constrained to start my practice as an advocate. I was not knowing anything about ABCD, about this law and everything. Only I was thinking that my father was great as an advocate, and I am also a great advocate. I was thinking at that time. But in fact I was doing, now I feel that I was not doing any ABCD of law. What we learn here in the law college is the practical, is the theory, and what we have to do in the course is the practical. But we were not aware of this fact. No one was there to tell us, guide us, all these things. And so, immediately in the month of June 1974, I was constrained to argue before N.V. Sasodkar Sahib, the then district judge. At that time he was additional district judge. And I was required to argue before him. And against whom? Against one eminent senior advocate, M.G. Bhagwat, was the senior most advocate. Because my father was contesting the matters. So at that time, the person who is opposing him was also senior. So I was required to continue the matter with those persons. In fact, madam, I swear that I was not knowing anything about appeal, civil appeal or anything. And I was there as a respondent's advocate. Mr. M.G. Bhagwat argued the case. I was not knowing what to do thereafter. N.V. Sasodkar Sahib told me that you continue and reply. As Madam, our Chief Guest has said that legs were shivering at the first time, the same thing was there with me also. For argument, you must have mastery, as rightly said by our Chief Guest, that you have mastery over the subject. And if you get all these three things, then you will become a good advocate. Not best advocate, but good advocate at least. So, with these, I remember now that moot courts are essential because all these things, these practical things we can get here in the college. How to conduct the case, how to argue the case. And remember that three things are essential for becoming a good advocate. And that I think that they are most important in the life of every student and every advocate. Number one, success is not final. Success is not final. Failure is not fatal. And it is the courage to continue that counts. So you have all these things must have with you to become a good advocate, good lawyer, and I expect that you will show your merits in this moot court competition. Thank you.
Professor Dr. Vaishali Rado ma'am and the faculty of this college, students from many law colleges and our students. So today
round will be between Team H and Team D. Team H is the petitioner and Team D is the respondent in this case.
The court here is on behalf of petitioners in the case of Andy and Monty and others versus Union of Sindhu. The council seeks permission to collectively address the bench as your lordship. The council seeks permission to proceed with the facts of the case. Much obliged. Monty and Andy and Muskan were 11 students as ASB Higher Secondary School in Sugurana. On 12 January 2015, Muskan accepted a ride from Monty and Andy. Andy allegedly coerced Muskan into non-consensual intercourse and Monty also participated. On 15 January 2015, Muskan filed a complaint and an FIR was registered under Section 63 of the Sindhu Nyaya Sanhita 2023 and Section 6 of the Protection of Children from Sexual Offences Act 2012. Monty and Andy were arrested, placed in Special Juvenile Police Unit and later released on bond. The Juvenile Justice Board initiated proceedings under Section 15 of the Juvenile Justice Act 2015 to assess if they should be tried as adults. On 30th January 2015, their parents challenged the constitutionality of Section 15 of the Juvenile Justice Act and Section 29, 30, 42 and 42A of the Protection of Children from Sexual Offences Act before the High Court of Sugurana, arguing that the juveniles should be not presently valid as they are a part of unilateral legislation. The Council now seeks to proceed with the arguments advanced. Much obliged. Honorable Court, it is humbly submitted that the present writ petition under Article 226 of the Constitution of Sindhu is maintainable as it challenges the constitutional validity of certain provisions of the Juvenile Justice Act 2015 and the Protection of Children from Sexual Offences Act 2012. These provisions violate the fundamental rights guaranteed under Article 14, Article 19, Article 20 Subclause 3 and Article 21 of the Indian Constitution. It is humbly submitted that the power of the judicial review is essential to uphold constitutional rights. In the state of Madras versus B.J. Rao, it was held that no authority can enact infringing fundamental rights. Your Lordship, the basic question in this issue is whether the court can declare any law as void or unconstitutional. Lordship, the people are the sovereign and even the parliament cannot take away the basic human rights of the people as per the doctrine of rule of law and its third postulates. It is the judicial duty of the court to protect rule of law and enforce fundamental rights of the people. Hence, the rule of the law, that is equality before law, is the fundamental principle of democratic governance. And any law which abridges fundamental rights can be declared as unconstitutional by this as per Article 13, Subclause 2 of the Constitution. Lordship, our Constitution is living Constitution which is organic and which believes in certain basic principles like firstly, constitutional morality, second, fair trial, and third, reformative approach, and which avoid the retributive approach of the state. Lordship, fundamental rights are basically negative burden on the state, and as the guardian and custodian of the Constitution, this court can invalidate even the actions of the lawmakers when they are violative of constitutional principles. Lordship, present petition is a child of the age of 17 years whose numerous fundamental rights are being violated, such as Article 14 as right to equality, Article 19 right to trade and profession, right to life and liberty as per Article 21 as stated in Maneka Gandhi versus Union of India, the right to dignity as per Article 21 which is also part of included in the judicial representation as it is also stated in the case Nas Foundation versus Government of NCT Delhi. Lastly, the most important right to education is as per Article 21A. Lordship, there is a grave need to decide constitutional validity of Section 50. Now we proceed to issue number 2. As stated by the director, the test of morality is the society is what it does for its children. We have seen the Indus Valley civilization and many more. Our society has never permitted such a kind of ill treatment to the child. Lordship, we have codified Juvenile Justice Act with certain objectives, where such objectives are firstly, rehabilitation over the punishment, second, cognitive development, third, protection of the child, etc. With the provisions of preliminary assessment of the children under Section 15 denotes retributive approach of state that is nothing but reverse theory of the social development. The classification of offences under Section 15 itself denotes that we have failed as a state that we cannot provide proper moral and ethical education to the children. Section 15 and the Rule 10A denotes from the Juvenile Justice Act legislative intent itself. Lordship, I want to make it clear that only the age cannot be a parameter, so as per Section 15, child between 16 to 18 will face preliminary assessment and it will be treated as adult offenders if found guilty. Lordship, what Section 15 focuses more on is personal competency of the child rather than social factors. And hence, Lordship, the age cannot be a valid parameter to decide maturity when there are other social parameters like firstly, peer groups, secondly, educational system, thirdly, family background, fourth, the law and order maintained by the state, etc., which controls the acts of the child. Lordship, Section 15 has created unreasonable classification where state has created special class of child between 16 to 18. This classification do not qualify the test of qualification where it takes the intellectual differentia and nexus with the object of classification as expected by Article 15 of the Constitution. It provides discretionary power to Juvenile Justice Board and where there is discretion there is room for arbitrariness and there are chances of non-use, misuse and negligent use of the provision by the concerned authorities. In Royappa versus State of Tamil Nadu as declared by Apex Court, every arbitrary action is violative of equality. A child subject to an adult trial and punishment is deprived of opportunities to reform and contribute to society, violating the right of freedom and dignity. As in the case of Maneka Gandhi versus Union of India, the Honorable Supreme Court held that any law affecting personal liberty must be just, fair and reasonable. Section 15 fails this test as it removes juvenile from rehabilitation system and subjects them to adult offenders. Every child below 18 is juvenile or child in conflict with the law. Section 15 treats few children as adults in violation of their equality. Lordship, there is violation of numerous rights due to Section 15 when a child is being treated as adult. There is violation of right to fair trial as per K.M. Nanavati versus State of Maharashtra. There is violation of dignity under Article 21. So as per Sheila Varse versus Union of India, it is emphasized by the Supreme Court that every juvenile must be treated with sensitivity and care and prioritize rehabilitation over punishment. Section 15 contradicts these rights and it introduces adult criminal system into juvenile justice system. No doubt the notation behind Section 15 after the Justice Verma and Subramaniam Swamy case, but we are having certain international obligations. Section 15 contradicts international obligations. USA, UK, Australia, these progressive countries do not provide treatment to the juvenile. Hence, Section 15 is unconstitutional as per Article 13, Subclause 2.
Honorable Lordship, the Council seeks permission to begin with issue number 3. Much obliged. Lordship, it is humbly submitted that Section 29, 30, 42 and 42A of the Protection of Children from Sexual Offences Act 2012 violates Article 14, 19 and 21 of the Constitution of Sindhu and must be struck down. As rightly said by Pascal, justice without force is powerless, but power without justice is tyranny. Your Lordship, children are innocent. We cannot expect from them to be aware about burden of proof, presumption of innocence, presumption of guilt and rule of evidence. A child is a child. As per the National Institute of Health's report, it states that up to the 18 to 20 years of age, a child cannot attain sufficient maturity to judge the nature and consequences of the act, and even Indian legal system believes that 18 years as the age of maturity. So as reliance can be placed on Indian Contract Act, General Clause Act, Hindu Marriage Act, Special Marriage Act, where the age limit is 18 years and everything below 18 is considered to be void. Now, the real problem is application of Section 29, 30, 42 and 42A to the child in conflict with the law, that is Juvenile Justice Act. As per the rule of beneficial construction, the view which is more favorable to the child is to be taken. Lordship, protection of children from sexual abuse as a special legislation is clashing with the Juvenile Justice Act and compelling court to pursue certain offences and provide maximum punishments to the juvenile. So firstly, Section 42A, which prescribes the overriding effect, dilutes the benefits under Juvenile Justice Act. It takes away the provisions of judicial interpretation which leads to injustice to the child. Lordship, Section 29 creates an unreasonable classification by presuming guilt in protection of children from sexual offences cases, unlike other criminal laws, violating Article 14 as stated in the case of D.S. Nakara versus Union of India. Lordship, Section 29 of Protection of Children from Sexual Abuse is unconstitutional in case of the child. The guilt must be proven by prosecution beyond reasonable doubt, but due to Section 29, this burden shifts towards the child, where a child below 18 years of age is not capable to establish his innocence and is injustice to the child of Juvenile Justice Act unconstitutional as it violates Article 14 and Article 21. Amend Section 29, 30, 42 and 42A of Protection of Children from Sexual Offences Act 2012 as they impose an unconstitutional presumption of guilt on the juvenile. Uphold the fundamental rights of the juveniles by ensuring a reformative rather than a punitive justice system. Grant any other relief that this honourable court deems just, fit and proper in interest of the justice. Much obliged.
What is preliminary assessment?
In which the mental capacity of a juvenile is examined, that if he is capable of committing that offence and he knows the nature and consequences of the act which is being committed by him.
And how this preliminary assessment is assessed?
Oh ma'am, it is done by various experts appointed by Juvenile Justice Board, which includes various psychiatrists, experts and certain social workers.
What that report is called then?
Children's Court.
No, who? All these psychiatrists and other committee members give some report.
Yes,
What that report is called?
the submissions has been made regarding it.
Any one of you can tell? What is that report called? Report regarding the child.
Do you find that before report of the committee under section 15 comes, the examination or any direction under section 18 of the act comes, before this was the right stage for to filing writ petition challenging the constitutionality of the section. Considering the stage of the facts before you, just committee decided to go under section 15. Number one. Report has not been received or neither any direction under section 18 are given. Whether this was, don't you find that it was a premature stage to file a writ petition to challenge the constitutionality?
No, sir. According to me, it is not a premature stage. As precaution is better than cure, it would come in future stage that they will file.
But then it could be in your favor also. How can you presume that it is going against you? What if they are going to physical capacity, mental capacity, and then thinking of what direction can be given under section 18.3? Then what was the hurry to go with the help of parent go to the High Court challenging the constitutionality of the Act? Number one, do you have calculation? Another question. Having read the facts, having gone through the number of date of birth from all the three, what was the exact date of all the three on the
Yes.
date of incident?
On the date of incident, one of them, Andy, that is, he was 15 years 4 months old, and another was 15 year 11 months old, and the victim on whom the crime was committed was something around 15 year 8 months old. So practically speaking, this act is not, section 15 is not applicable to them as it covers the people who have completed
If
the
you have
age
gone
of
through
16.
those
We
date of birth.
cross-checked that facts with the college, and they informed us to make it appropriate that section 15 will be applicable. The age up to 16 we have to consider. We had cross-checked that.
But in your argument, that particular part, you did not argue even. That none of all these three have completed age of 16 years.
Sir, already the college had given clarification regarding that we have to
Okay.
consider 16.
Have an alternate to effective remedies. Your Honor, the Juvenile Justice Act 2050 and the POCSO Act 2012 provides statutory framework for the challenging any adverse decisions. Doctrine of alternative remedies as per no fundamental right has been violated. The petitioner have not demonstrated the direct violation of fundamental rights. Article 226 jurisdiction applies only in the case of violation of fundamental rights, lack of jurisdiction, natural justice violations, arbitrary or unconstitutional actions. The challenge to section 15 of Juvenile Justice Act and section 29, section 30, section 42, section 42A of the POCSO Act is policy matter that fall under the legislative rules, not under the High Court's judicial review powers. Your Honor, doctrine of presumption of constitutionality. Legislative and enactments are presumed to be constitutional unless proven otherwise. The case is State of Bihar versus Dhaneshwar Singh, 1952. The burden of proof on the petitioners to demonstrate the laws in questions are unconstitutional, which they have failed to establish at this stage. The writ petition under Article 226 is maintainable only in the limited cases. The High Courts can entertain writ petition if the law is ex facie unconstitutional, there is a gross misuse of power, violation of natural justice, the case involves a matter of public interest. However, in this case, the petitioner have not met these conditions, either the writ
the Juvenile Justice Board be allowed to conduct the preliminary assessment under the section 15 to determine whether the accused should be treated as an adult. The special court to be permitted to proceed with the trial under the POCSO and Sindhu न्याय Sanhita. The state be allowed it to enforce POCSO protective provision, ensuring the justice of served for the victim.
I have nothing to further, sir.
Now this petitioner has challenged and filed this appeal according to you.
The stage of the proceeding in the before juvenile justice board, whether the stage was proper to go in writ.
There is a trial court or special court. There is no statement in
What is that court called where the cases of children are put up? What is the name of that court?
juvenile justice board.
Who are the members there? Can you answer at what stage this petition is filed?
The lower court, adequate court are responsible. Decision in pending.
Do you know the proceeding of juvenile justice board? How that proceeding works? What are the stages? Why these children are produced before juvenile justice board?
Because they are juvenile.
Juvenile, what is meant by juvenile? And what is the appropriate word now which is to be used for juvenile? Huh? No? No, that victim is different. Now, this is as per the criminal hierarchy, this is accused. Huh? So, about children, when we are talking about child, then what we should call him? Can we call him accused? Is it a proper word? Then what should we call him? Okay. Thank you.
Much obliged. My opponent counsel put forth the point that no fundamental right of our petitioners is violated, but it is clear from the facts that the case that there is grave injustice on our petitioners. Under Article 14, 19 and 21 of the Constitution of Sindhu.
What about the act? Provision in the act. What about the provision in the act? JJ Act. Provision of section 15 and section 18.
Section 15 preliminary assessment, as stated in our arguments, if it is considered that section 15, if it is brought into the current scenario, then section 14 itself violates it, because if we consider that the juveniles are mature enough to commit the offence, then why the preliminary assessment should be done?
They have to form the opinion. For that purpose, section 15 is made. Therefore, there is a separate group has been made for 16 to 18. to decide in respect of the crime which are more severe and heinous against the child. And therefore that has been tried to be distinguished from by section 15, and it is the duty cast on the responsibility for JJB to look into the matter for the purpose of mental capacity and physical capacity of the child before them.
But sir, we are talking about the constitutionality of section 15.
But that
As the juveniles in the age group of 16 to 18 should be treated as juveniles, as this section contradicts the main purpose of Juvenile Act, that is to make rehabilitation and reformation of the juveniles.
that is already provided in the Juvenile Justice Act.
There is a reverse journey towards, as we are reformative, there is a reverse journey that we are bringing again the age group of 16 to 18 under the ambit to be tried as an adult.
What do you want to say?
In reply,
Nothing?
Court, Antamuka P. on behalf of the petitioner, on behalf of the Monty and Andy. We stand here, this honorable court, today to demonstrate the imperative need to protect the constitutional right of our client. The council seeks the permission to proceed with the facts of the case. The petitioner, Monty and Andy, are students of the ASB Higher Secondary School in Sugra, a state in Sindhu. On January 12th of 2025, the petitioner offered Muskan, the respondent in the pending matter, the bike ride because of the stringent weather. Subsequently on January 15, 2025, Muskan filed a complaint alleging sexual offence against the petitioners. Based on the said complaint, FIR was registered against the petitioner under section 63 of the Sindhu Nyaya Sanhita and section 6 of the Protection of Child from Sexual Offences Act 2012. The petitioner were apprehended and produced before the Juvenile Justice Board on January 18, 2025 and subsequently released on bond. The Special Juvenile Police Unit SJP submitted a final report charging the petitioner under section 63 and 70 of the Sindhu Nyaya Sanhita and section 6 of POCSO Act 2012. The petitioner through their parents have filed this present writ petition challenging the constitutional validity of the section 15 of Juvenile Justice Act and as well section 29, 30, 42, 42A of POCSO Act 2012 due to the concern regarding the fundamental rights and the principle of the justice. The council, with due permission, seeks to proceed with the jurisdiction of the court. Consequently, and with the stated factual background in mind, I respectfully submit that this honorable court is vested with the appropriate jurisdiction to honor this court. The petitioner has invoked the writ jurisdiction of court under Article 226 of Sindhu for violation of fundamental rights enumerated in the Part 3 of the Constitution. The petition challenges the constitutional validity of Section 15 of Juvenile Justice Act and Section 29, 30, 42 and 42A of the Protection of Children from Sexual Offences Act. The council seeks the permission to proceed with the issues. With the jurisdictional aspect being clarified, we now proceed to the central issue that demands the honorable court's judicious consideration. Issue number 1 is whether the writ petition filed by the petitioner before the High Court is maintainable. Second issue is that whether Section 15 of the JJ Act, Juvenile Justice Act, and is constitutionally valid in the light of petitioner's right under Article 14 and 21 of the Constitution. Issue number 3 is whether Section 29 and the 30 of the POCSO Act 2012 violates the fundamental right of petitioner by shifting the burden of proof. Last and the most fourth issue is whether Section 42 and 42A of the POCSO Act conflict with the JJ Act and whether such an override is legally sustainable. The council seeks the permission to proceed with the summary of arguments. At the summary of the issue 1 is that writ jurisdiction of the High Court under Article 226 of the Constitution safeguards to protect fundamental rights. The petitioners, juveniles, seek redress against Section 15 of the JJ Act and Section 29, 30, 42 and 42 of the POCSO Act. The maintainability is imperative given the grave constitutional questions and irreparable harm faced by the petitioner. The High Court's jurisdiction is expansive and plenary, ensuring no individual is left without remedy. Second summary is the constitutional validity of Section 15 of the JJ Act 2015 is under scrutiny as it infringes upon the petitioner's fundamental rights under Article 14 and under Article 20 of the Constitution, and mandates a preliminary assessment to determine whether juvenile aged 16 to 18 accused of heinous offences should be tried as an adult. The provision is a legislative overreach that violates principle of equality, fairness and justice. The third summary of the issue number 3 is Section 29 and 30 of the POCSO Act violates the petitioner's fundamental right as reversing the burden of proof, contravening the presumption of innocence under Article 21. These sections require accused to prove the innocence rather than the prosecution proving guilt beyond reasonable doubt. This provision eviscerates the right to fair trial as mandated by Article 21 and lacks the procedural safeguard further exacerbating the injustice. And the last summary of the issue number 4 is Section 42 and 42A of the POCSO Act conflicts with Juvenile Justice Act. This override is legally unsustainable as it subjects juvenile to adult trials and punitive measures contrary to the welfare-oriented approach of the Juvenile Justice Act. The Council seeks the permission to proceed with the argument at once. Issue number 1, where maintainability of the writ is in the question. May it please the court, the council seeks to address the preliminary yet critical question to whether this honorable court can properly hear and entertain this writ. Opposing counsel will undoubtedly argue that the court lacks the power to hear our plea. With due respect, however, such contentions disregard established legal principles, misrepresents the core nature of this petition, and if adopted would result in manifest injustice to our client. To the end, note after page 4, petitioner page number 4, paragraph number 1, in our submissions, it is crucial to be here in mind that writ jurisdiction of the High Court as enshrined in Article 226 of our Constitution is far more than mere procedure Juvenile Justice Act. May it please the court, may I please the court to overlook the page number 7 of the memorial, where Section 15 of Juvenile Justice Act, Section 15 is challenged. With utmost respect, we submit this provision rather than serving as a protective measure is a direct violation of constitutional values, creating arbitrary classification and lack of fundamental procedural safeguard. As noted on page number 7, paragraph number 10 of our written submission, the Juvenile Justice Act through Section 55 mandates its term as preliminary assessment for juvenile aged 16 to 18 who are accused of heinous offences. While the stated intention is to discern whether these individuals should be treated as adult in the eyes of the laws, we firmly assert that this process is not merely a balanced determination, rather it is a legislative overreach that fundamentally violates the sacrosanct principles of equality, fairness and justice guaranteed under the Constitution. Further, page number 7, paragraph 10, Section 15 draws an unreasonable distinction between juveniles below and above the age of 16 years. This arbitrary classification lacks an rational basis, bearing no reasonable relationship to the legitimate objective of the Juvenile Justice Act, which is the care, protection and rehabilitation of the children in conflict with the law. Further proceeding, it is settled tenet of law that classification must be grounded in an intelligible differential and bear a rational nexus to the object of the statute. As this honorable court is aware, this principle ensures that the law treats similarly situated individuals in a like manner and prevents discriminatory application of law. In that regard, the petitioner would like to bring the honorable court's attention to the following arguments stated in the Maneka Gandhi versus Union of India case. My lord, please refer page number 8. A statute in the case of Maneka Gandhi versus Union of India, a statute not only prescribes a procedure but also ensures that the procedure is fair, just and reasonable. In the case, the preliminary assessment under Section 15 is not based upon any objective criteria of the guideline. Rather, it is left to the subjective discretion of the JJD, thereby rendering it arbitrary and discriminatory. Further, Section 15 also violates Article 21 due to lack of procedural safeguards. My lord, please refer page number 9, paragraph number 4. Here, the assessment lacks clear guidelines on procedural safeguards, exposing juveniles to arbitrary decisions that jeopardize their fundamental rights to life and personal liberty under Article 21 of the Constitution. There are simply not enough process and systems placed ensure fair and just decision. As Supreme Court has emphasized in the number of numerous cases, the right to life as enshrined in Article 21 includes right to fair, just and reasonable procedure. However, this right is hollow without adequate procedural safeguard. Thus, assessment under Section 51, which lacks basic protection, exposes juvenile to wins the JJB, thereby undermining the very essence of right. May I know the remaining time, please? Okay, I would like to address issue number 4 in short. May it please the Honorable Court to refer page number 16, paragraph number 1, where the direct conflict between POCSO Act and JJB is being contended. Section 42 and 42A of the POCSO Act, which pertains the procedures, recording statement and granting bail, directly contradicts the specialized procedure outlined in the JJB Act, dealing with children in conflict with law. With due respect, this conflict places juvenile in an untenable position, subjecting them to legal framework that is ill-situated to their needs and potentially harmful to their rehabilitation. And the last contention in this issue, dominance of JJ Act, Juvenile Justice Act, in matter concerning juveniles. As asserted in page number 17, paragraph number 2, the Juvenile Justice Act, being a comprehensive and specialized legislation dealing specifically with children in conflict with the law, should take precedence over the general provision of the POCSO Act. Is matter concerning juveniles. This principle is well established in legal jurisprudence, where specialized statutes are given priority over general ones in the specific domain. In conclusion, may it please the court, Section 42 and 42A of the POCSO Act, when applied to juveniles, create an irrevocable conflict with Juvenile Justice Act, undermining the principles of juvenile justice and violating India's international obligation. The Council seeks the permission to further proceed to the prayer. Whereof, in the light of the grave constitutional questions raised and the irreparable harm faced by the petitioner, this honorable court is respectfully prayed to declare that the writ petition filed by petitioner is maintainable under Article 26 of the Constitution of Sindhu. Second, strike down the Section 15 of Juvenile Justice Act, and as it violates Article 14 and 21 of the Constitution, declare that Section 29 and 30 of the POCSO Act is as unconstitutional to extend they shift burden of proof to the accused. Hold that Section 42 and 42A of the POCSO Act conflicts with Juvenile Justice Act 2015 and that such an override is legally unsustainable. Grant an interim stay on proceeding pending before the Juvenile Justice Court under Section 15 of the Juvenile Justice Act to prevent irreparable harm to the petitioner. And the last, pass any other order or discretion that this honorable court may deem fit and proper in a circumstance of the case, ensuring the protection of the petitioner's fundamental right. And for this kindness, the petitioner shall bound to be. I would like to rebuttal to.
The respondent seeks permission of Honorable Court to address the bench as Your Honor, Your Lordship or Your Ladyship. Much obliged. May it please the court.
1. Have argued that writ petition is not maintainable. May I request the researcher to pass the question paper of the rebuttal, question of rebuttal. Okay. Much obliged. The respondent asks that the writ petition is not maintainable due to alternative remedies under the Juvenile Justice Act. However, can a respondent explain how these alternative remedies address the petitioner's challenge to the constitutional validity of Section 15, as no remedy in Juvenile Justice Act is provided regarding the constitutionality or challenge the constitutionality of Act. And in similar issue, the respondent urged that regarding the premature invocation of the writ jurisdiction, may I urge to refer page number 6, paragraph number 6. Here the respondent urged that invoking writ jurisdiction is premature as statutory remedies under Juvenile Justice Act have been exhausted. However, can they clarify why constitutional scrutiny should wait until after a potential flawed preliminary assessment process is completed? Shouldn't immediate intervention by warranted when fundamental rights violation alleged? Some of the questions are from the respondent which are not been addressed. So shall I proceed or shall I proceed? Regarding issue number 2nd and 3rd, which has not been addressed. Of the respondents, actually I am reverting the question which the respondent to be time concerned didn't address. So shall I address?
For the information of my opposite respected counsel, I have addressed all the 4 issues. I will be answering the rebuttal questions mentioned. In the present cases, the petitioner stated that there is no violation of the fundamental rights, whereas there are the alternative remedies available. While the alternative remedies are available, that is stated by our respondents, in the present case, the petitioners have statutory right to challenge the preliminary assessment conducted by the Juvenile Justice Board under sections 15 of Juvenile Justice Act before the appellate jurisdictions. Sections 101 and of the Juvenile Justice Act and section 102 confer the power to appeal the children's court against the orders of JJB. That is what the respondent states, that is the alternative remedy. Nextly, there is no direct fundamental rights or violation. My respected opposition petitioner enlightened paragraph number 6, page number 6, that there is no direct fundamental violation of the rights. Whereas negligence, my lord. The Honorable Supreme Court in Union of India versus T.R. Verma held that the writ jurisdiction should not be used short-circuit the statutory process, especially when the statute provides a detailed mechanism for redressal of grievances. In this case, petitioners have not demonstrated any exceptional circumstances justifying such invocation at this stage. Hence, their writ petition remains premature and warrants dismissal outright. While there are no direct fundamental rights violated, statutory procedure must be followed before constitutional scrutiny. The respondent further submits that the petitioners have failed to establish any direct violation of their fundamental rights that would justify the invocation of the writ jurisdiction under Article 226, the Constitution of Sindhu. Petitioner challenged the constitutionality of Section 15, Juvenile Justice Act, Section 29, Section 30, Section 42 and 42A of the Protection of Children and from Sexual Offences Act 2012 based upon the speculative and hypothetical grounds without any concrete evidence of violation of their fundamental rights. Highly obliged.